will discuss about the power of the directors. Okay, so a company, okay, so there will be many who has the power to control it. So actually the power within a company is divided between two groups. Okay, let's see. One is the board of directors. Okay, they have the power to manage the business on a day-to-day basis and all. Then the other group is the members. Okay, they can make major decisions about running the company's business on general meeting and all. So the power within a company is divided into two groups. One is the board of directors, the other one is the members. Obviously members who has major influence, so they can control over the company. So all these directors exercise true power, and all it is written in the constitution of the company. That is the article of association of the company, how to exercise and what the directors have to exercise the power. So the directors have to exercise the power in order to manage the company's business. And also they have exercised all the power of the company for any purpose connected with the company's business. For this, the directors can exercise their powers. One to manage the company, the other one is to, yes, whatever purpose connected with the company's business, the article has given the directors the right to exercise the powers. And in articles, okay, in some articles there will be some powers that is delegated to the directors in order to manage the business and all. So after yes, so the directors are delegated their powers, and the directors make decisions with the powers they have. So these shareholders, okay, these shareholders cannot interfere in those decisions which the directors made, because they are given those powers in the article of association. See, you are the shareholders and the director. We have the company, we have the constitution of the company, that is the article of association. In this it is already written the powers, okay, already written the powers to exercise and all of the for the directors, okay. And more than that, they delegate some of the management to the directors. It's already written here, and me, I'm the director. So with that power, what I do is that I make a decision. In that decision, you, the shareholders, cannot interfere. Okay, so all we learned till now, we learned what the directors are the agent of the company. They are not the agent of the shareholders, so they don't need to listen to the instruction of the shareholders and all. Okay, but there is a twist in this. Okay, what all I said right now, that is true. It will go like that. Everything is right, but there is a twist, and let's go to the twist. The twist is that sometimes in some things there are restrictions for the directors. In that, when they have those restrictions, the shareholders has more power than the directors, and kind of they can control the directors. Okay, let's see how. Okay, and what are the restrictions? So some actions require a resolution. Okay, a resolution by the shareholders, that the members of the company. We say directors can make decisions towards the business activity of the company, but for some actions it requires a resolution by the shareholders. And if a director has to be removed at any time, if the shareholders, that means you people, if you think that I'm a director, I'm not going towards, or I'm not working towards any of your interest or anything. So what you do is that you can remove me at any time just by an ordinary resolution of the members. Okay, with the ordinary resolution of the members, you can remove a director. See here, what will be a shareholder's mind? Their mind will be as their benefit. Do they look the benefit of the company? No. How do they get the benefit? How do the directors work in their way to make the benefit? Okay, they don't look only what is good for the company. They look what is good for them. Then only maybe they will look what is good for the company. So those the directors who is not going in their way at all, they can remove the director. Okay, so here it is a restriction for the directors, right? They may see fit to exercise this right should their views be ignored. And just in the before section, we discussed a point. What did we discuss? Yes, the articles will give rights or the power to the directors in order to manage the business, and whatever decision the directors make, the shareholders cannot interfere in it. Here, listen, okay? Actually, the members have the right to alter or change the things in the articles by passing a special resolution. Okay, so you're the shareholders, I'm the director. With the help of the article of association, I made a decision, you cannot interfere. So next time or any other time, what you shareholders does is that you alter that power. Okay, you cannot interfere the decision that I already made, but you can actually change the actual thing in the article, or the power that is giving to me, you can change that, right? So what you do, you don't interfere in my decision, but you go directly and alter the articles by passing a special resolution. Okay, this power could therefore be used to restrict the director's powers. So to remove a director, we need ordinary resolution, but to alter the article, we need a special resolution. Now, statutory control over directors. That is, certain matters require the approval of the members in a general meeting in order to be valid. Okay? Then only it will be considered valid. Then, director service contract. Director service contract is for how many years? 2 years. So, if it needs to be more than 2 years, it should last more than 2 years, the director service, then we need the approval of the members of the company. We already discussed that point. Okay, so here you can see the power of the members more than the directors, and therefore there's restrictions to directors. Okay, so a substantial property transaction between a director and the company needs the approval of the members. Okay, that is a substantial non-cash asset. What is substantial? Substantial means that has some, it is considerably important or size or worth, okay, its value. So there are some guidelines, okay, for to consider an asset as substantial. So let's see what or when a asset will be called substantial. So one is that its value should be more than euro 100,000. If an asset value is more than euro 100,000, then it is substantial. Or it exceeds 10% of the company's asset value. Okay, then it will be considered substantial. So it does not mean that if the company has an asset value, it's very less. Okay, a very small asset value. Okay, a company's asset value is very less, then the 10% of that small asset value will be considered substantial. No, at least it should be more than euro 5,000. Okay, then only it will be considered substantial. So what are the things that asset will be considered a substantial? Yes, one, it exceeds more, its value exceeds more than euro 100,000, or it exceeds more than the 10% of the company's asset value, that is more than euro 5,000. Keep that in your mind, okay? So what if such a transaction happens and we fail to obtain the members' approval? Okay, what are the consequences? See, one is that the transaction will become invalid. Okay, invalid if the members didn't give the approval within a reasonable period, or whatever the director gets from it. Okay, if the director made a benefit from that substantial property transaction, then the director have to pay back to the company, or if there was a loss for the company, then the director have to pay the damages. Okay, so these are the consequences the if they fail to get the approval of the members. Then loans to directors, they need the approval of the members. That is, any loans or guarantees provided as security for loans must be approved by the members. Then non-contractual payments to directors. We discussed this before. That is, if the payment is already written in the service contract between the director and the company, that if there is a loss of office, the director will be paid this much, then there is no need of anyone's approval. Okay, the company can pay it, but it's not there in the service contract. Okay, then the company want to pay something to the director in the loss of office, then that needs the approval of the members. Okay, so these are the things where the members have more power, that means their approval is needed. Okay, authority of directors. So a director is given the authority by the company. Okay, is given the authority by the company either by express, implied, apparent, or ostensible. Then they go and bind to a contract. Okay, they make a contract with the third party, then the company will be bound to it. Okay, so express authority means that it is expressly given, the authority is expressly given to the director, and whatever decision the director make within that express authority, the company will be bound. Then implied means from that position we can understand that that person or that director in that position has this much power or the authority to do things, right? So a person is appointed as the managing director. We know from that position that this director will have this and this authority, and if they get into within that authority, if they get into contracts, it will be, yes, bound to the company. And MD and CEO, in that position, whatever authority MD or CEO will have, that person will have that much authority as a MD or a CEO. Then apparent or ostensible. That means if a board of directors, they hold out that this particular director has the authority to do this, okay, then that authority is known as apparent or ostensible authority. If a third party thinks from the holding out or from the representation that this particular director has this authority to get into a contract with me, and this will be bound to the company. If a third party from the representation of the director, he understands that way, then yes, the company will be bound to it. Do you remember this case that we discussed? The Freeman and Lockyer versus Buckhurst Park Properties? Yes, what happened in that? The board of directors, they didn't deny, okay, they didn't deny saying that this, or they didn't disapprove saying that this director didn't have the authority to do that or anything. Actually, all those time they was okay with whatever that particular director was doing, right? But later on, when a case came, okay, the third party believed that this director has that authority to do, and later on a case came, the other directors of the board said, we didn't give the authority to the that particular director to get into contacts with the third party. Then then they went to the court. It was disapproved because did they deny it before? that particular director didn't have the power or the authority to do something like that? No, they didn't do that. They were okay with it. But suddenly when a case came, they just said it that the director was not given the authority. Actually, it was hauled out. That means apparent or ostensible authority was given to that director. Okay, so that's how the directors will get into a contract, and they have the authority to get into a contract, and the company will be formed. Express, implied, apparent, or ostensible. Thank you, and please attempt the practice questions after this session. And if you have any doubts, feel free to ask in the Q&A session on the left panel or drop an email to support@untanglex.com. Thank you. Have a great day.